Welcome to this NORA startup webinar. It's webinar number 19, and today we're going to talk about when AI meets law. Because during this NORA startup webinar, we will delve into the fast developing world of law and AI. We will learn about how AI is transforming legal practices and the nature of legal research. We all know that AI is a rapid pace development, and it's being implemented all over the place, also in legal tech. That includes fair ensuring of people, correct billing, drafting legal documents, and data analysis. But as in every other field, there are certain ethical and practical challenges that we should overcome, and we will learn about how these three companies really delve into this, because we will talk about with Vito De Luca from Lexploria, Merete Nygaard from Lexolve, and Rebecca Schmidt from University of Oslo. Merete Nygaard is the CEO and founder of Lawbotics and also the initiator of Oslo Legal Tech. Merete has started up Lawbotics after a decade of working with established law firms. After that, we will hear from Vito De Luca, who is the founder of Lexploria and also a professor at the Faculty of Law at the University of Tromsø. So in addition to that, he has a significant past in computer science and involved in startups such as Zoomit, not Zoom, but Zoomit, and Kelco. Last, but of course not least, we will hear from Rebecca Schmidt, who is a postdoc research fellow at the University of Oslo, working in the Virus project. And for those who have not heard about Virus, it's the vulnerability in robot society. And her research explores the interplay between public and private regulation in the field of AI and robotics, mostly focused on the EU level legislation. My name is Morten Gudvin, and I'm a professor of computer science working on artificial intelligence from University of Agder. And today I'm representing NORA and NORA.startup. So NORA.startup is a national network that focuses on research-based innovation and work to facilitate a tighter dialogue between academia, students, and startups in AI, machine learning, and robotics. We will start by having a presentation, some with slides potentially, some without, and then after that, after 10 minutes from each speaker, we will have a debate. So every listener, please prepare your questions. If you have questions from either one, Merete, Rebecca, or Vito, or from all, or about AI, law, legal tech, how they start up, what is the way to finance things, what is the way to go forward. If you have a similar idea, this is your time to ask. And without further ado, we will start by giving the floor to Merete. As I said, she is the leader of Lexolve and founder of Lawbotics. So Merete, the floor is yours. We're very eager to hear more about your work.
Thank you, Morten, and thank you for this intriguing introduction to the subject of AI and law. So let's see how I can contribute. A little bit of me, and yeah, of course, feel free to come with questions, so it feels like sort of an interactive session. As you can see, I'm in my office of Lexolve. I'm the founder of Lexolve. The formal name of the company is Lawbotics, so hence the name confusion. Mm-hmm. So I am formerly I worked as a business lawyer. So my education is law, so please don't ask me very complicated technical questions. But what I did, so it's been now actually 5 years since I quit law and my law career to now build sort of an AI solution within legal tech. But I want to take you back to for when I work and the problem I saw, because I used to work with technology companies, small companies. I was advising intellectual property, contract law, dispute resolution. And what I saw that when I had small companies and clients coming, asking me to say, can you create this distribution agreement for me? Or can you review this NDA? Or what should I do with this question? Do I need marketing consent? Can I do this? I felt that a lot of the times I was giving answers that either someone in my company or lawyers had done before, or was somewhere in the system. I just couldn't find it. So I felt that I was reinventing the wheel again on the client's expense. So I felt it was a very bad, I guess, distribution and consolidation of legal knowledge. And that was a problem that ended up with the companies paying more than I think they should have to, but also the bigger problem, which is quite a lot of small companies do not access or use lawyers at all, for the simple reason that it's too expensive. So it means like most companies, say with less than 50 employees, never go visit or ask a lawyer for something. They actually try to solve the problem themselves, or not at all. And when they try to solve their problem themselves without legal qualifications, it often ends with a bad solutions. So not having the ability to ask a lawyer or ask someone who has legal competence in ongoing matters in the business can lead to quite worse outcome. It could mean that they experience losses, that they end up in disputes, that they miss out on profit, and in worst case, they could actually go bankrupt. So one problem is sort of the bad scaling of knowledge, but also the consequence of that is that for small companies, at least, that they don't get access to justice. They don't get access to the legal advice, which have made their business more sustainable. So that's the introduction to the problem that I saw and wanted to solve. And that's what I set out on the journey for robotics, was actually to see that I did see the headlines, the robots are coming, AI is going to change the legal professions back then. So I was like curious, how could that actually maybe solve the problem that I see? And I tried to figure that out. It wasn't actually very advanced at that time. I still don't think it is, but that's for the later debate. And figured out that I could actually do something because not so much was already done. So the first thing I did 5 years ago was to start to create an automated document automation to sort of imitate a lawyer-client conversation. So the system were asking questions and the user were answering through the system, and then the document was customizing to the user's need. So classic decision tree logic behind that. And that's been quite a lot used. We have 102,000 users of that systems today, and they find it very simple to solve their own legal task. But that's not enough. So creating documents, yes, that's part of the solution, and it's part of sort of the bread and butter of what lawyers do. That could be automated, was sort of the simplest thing to do. But the next thing that we are now doing is that often you need something more. You need more guidance and you need legal advice. So we are creating now what we call a digital lawyer, which will help small companies solve their problems, that can help them solve tasks and answer questions, and also give recommendations on what they should fix going forward. So this is quite a leap from the document automation system, but the document automation system was quite crucial, or essential step on the way, because it trained the users to try to solve legal tasks through a digital system. So our goal with this new digital lawyer system is that we are using machine learning AI to assist the digital platform it's an AI assisted digital platform for legal services. So the end goal using AI is not to use it in an aim for itself, but it's to see where can we actually save operational costs, because we have human lawyers that helps delivering services through our digital platform. And to do that efficiently and also at the cost or a price for the user that they can afford, we need to be super efficient in how we deliver that advice. So that's where the AI come in. So the project we have I guess it's quite a long project where it's going to be really, really well functioning. But we are on a good route already, because we are now creating the architecture for data gathering that we need around human lawyers and how they work. So we're trying to be very efficient in creating or gathering data from the user itself, public data from similar companies, and try to sort of predict what's going to come next, and also in how we understand what the problems are. So our goal is to gradually learn and recognize patterns, so we can connect legal situations to problems, and from problems to legal solutions. In a nutshell, it actually sounds simple. I guess it's not. But that's what we are working on, and as far as I can tell, it's not the system that does this, at least not in Norway. So I think that's my introduction, Martin.
That was very, very interesting. So, would you say that your strength is that AI gives you a niche you can find in the legal tech, or does it give a strength overall over other law firms? You would say. So in the essence, you're kind of a law firm that uses technology, if I understand it correctly.
Well, no, I wouldn't use that description. We are not a law firm at all. So I think that it's like normally you see what can AI do within what lawyers already do, which is sort of a wrong perspective for us. We are only focusing on the user needs and tailoring sort of design system around the user. So I would say we are sort of trying to change how both legal services are consumed and delivered. So it's consumed in a different way through a digital platform, and it is delivered through that platform too. So we've been quite different than a law firm, I would say. And also, we don't compete for the same type of customers. We are addressing this market that has had very little access to legal advice before. Right. Namely the small companies it's mainly high margin industries that use and pay for lawyers today.
So you kind of people who never had access to lawyers before get some sort of legal support, or at least legal advice or legal help from you. So that's very
it's sort of subscribing to their own legal department, which has not been available for them before.
Very interesting. We'll of course hear much more about you and your work in the discussion we will have later, because now we're getting over to Vito, who is a professor at University of Agder, also founder of Lexploria, and we're very interested to hear more about what is Lexploria and how does that fit into the academic world of a professor. So some professors don't want to touch the private market at all. It seems Vito is very different. And why is that? Vito, please help us understand.
Thank you, Morten. So first, let me thank Nora for inviting me here, and I also want to thank Merete and then in anticipation Rebecca. So Merete has been very instrumental for the whole legal tech environment here in Norway. So it's very nice to be here and be able to share this panel. So yeah, so just a few words first on why I got to start this journey into the private business. So first and foremost, it's partly is because of my past. I have like a dual past, or dual, I don't know, Dr. Jekyll and Mr. Hyde soul maybe, but I had a long experience after I got my law degree. I got to shift over to private industry and worked during the internet boom, and I've been involved in a number of startups, and I've been there in that industry for about 10 years until that experience kind of concluded itself, and I went back to law. But I guess that has remained a bit latent, that experience and that interest. And then after I progressed in my academic career, and suddenly legal tech started to circulate as a thing, and you know, immediately I kind of sort of saw how I could kind of bring together maybe these two parts of my career, my past, and my things that I enjoy. And in a sense, I've also represented my first use case or you know, pilot user, because the motivation for me to start Lexploria which is really aimed at enhancing the way that legal research is conducted, stemmed from my idea that of all the operations that you do as an academic lawyer or as a legal researcher in general, with differences that apply in the different kind of sectors. And there's a number of these operations that could really benefit from the application of advanced algorithms that would streamline a sort of operation, would speed up enormously the pace of these operations, and could also introduce new methodology to look at how legal research is conducted. So there was a lot of interesting questions that popped in my mind. And again, in a way, also thanks to going to Oslo Legal Tech, and so these things kind of brewed inside. And then at one point, which is not long ago, maybe it's 2 years, just about these days, I decided to take the plunge, as one say, and start Lexploria. And so, I mean, the Lexploria is still very early stages. It's still a like evenings and weekends company, and the pandemic hasn't helped in that respect. But we come, I would say, a good way. And but again, the focus is really to develop algorithms that allow to make legal research quicker, smarter, and also to open up new venues to see relationships between legal documents. And so there's like an enormous amount of things one could say in that respect. And the idea of Lexploria is to develop products, and some of which are going to be released in beta version in not so many days, if all goes well, fingers crossed. But products that can be of use, again, with the difference of the case to both legal practitioners, academics, and students. And at the moment, and also in a way, maybe this is the academic side that I don't look at this pragmatically, but I have this ambition of really gathering the entire legal data set that exists in the world and try to use that as the basis. And of course, there are many differences in terms of the different legal data sets and the different legal jurisdictions that create a number of issues in terms of how you develop algorithms and what kind of operations are useful. But this is the overall ambition. I'm an international lawyer, so I work with international primarily, so that's the starting point. And out of material constraints and pragmatic reasons, even though I just said I'm not a pragmatist, the first product that Lexploria is going to release, again, hopefully very, very soon, is based on the European Court of Justice dataset. And so utilizes the full set of decision of the court to deploy algorithms that will use both quantitative and qualitative methods to extract information. We're focusing a lot on citation networks, on developing the authority ranks, and developing different kinds of ways to kind of extract and mine information from these documents that can be then accessed through a dedicated app. So this is, I guess, in brief, what I can say to start with, and then I'll be happy to answer any questions. I may also have some questions on my own.
Sure.
And also, again, a bit of disclaimer. So even though I've been working with in tech companies, in fact, as a software developer and UI designer in this past, I still approach this mostly from a legal point of view. So deep questions about the AI may be misguided at me.
So we'll find a way to ask the questions in the correct way, I think, Vito. But I'm really curious. So where is the machine learning part in Lexploria? So is it to enhance search, or is it something different?
So it is to enhance search, but it's aimed at really interpreting the text. So we are deploying or starting to deploy. This is a long journey, natural language processing, in order to understand the way that the connections between documents are articulated in linguistic terms, and to understand So it really, in many ways, the idea is that, well, I wouldn't want to say that I want to use this to substitute operations that humans do, but they want to really address the type of operations that we do when we look at the documents, and we may, I can say, a very, very smart research assistant. That would be maybe the good way to put this, in terms of how cases are discussed in the literature, for example. And I think the literature, I'll mention it here, and then maybe we can talk about it in QA.
Mm-hmm.
It's so we start from court cases, and then also legislation in our pipeline as data sets. But the real aim is to access and process the scholarly literature, because that's where the most interesting things can happen, in terms of really deploying deep learning and natural language processing algorithms that can really take the use of algorithms to the next step in terms of, in particular, research. I think maybe the one challenge for me as an academic is to really see the applications that are commercializable.
I feel just a fellow academic. So in a way, kind of like the search engines of the 2000s, Google, most famous, replaced in many ways librarians. You're saying that you want to support or replace research assistants in some way, a very smart one. Did I interpret you?
No, I wouldn't want to replace them at all, but I think it's just another tool which would change a little bit the way that then research is conducted. It would complement it, but it wouldn't substitute it. I find it hard to believe that unless you develop general AI, that you can really create a substitution. It's right. Really a complementing. The tasks are really still driven by the programmer, the software development. There's also such a subjective element in legal research that you could have two algorithms that are developed by two different companies, and they will come up with slightly different outcomes in terms of the way that certain textual elements are interpreted, because the subjective element, at least that's my theoretical framing, it's so different. So it will be a complementing.
Okay, great. So and then you're implying then that the general AI is not part of Lexploria, which is good to know, I guess. And I guess it's not part of Rebecca's research either, because that's many years in advance. So the last speaker today is Rebecca Schmidt, postdoc at the University of Oslo. And I know you had some technical issues there, Rebecca, so I'm curious, are you presenting some slides, or are you?
They should be resolved. I will try my best. I'm very glad that Vito's program wasn't up and running in my early days as a researcher, because he would have really taken a source of income for me. But so yes, my presentation will be, can everyone see it? Fine?
Yes.
Great. Yes. So I will have a slightly different perspective from the other two, with those really focused on how AI assists in the both practice or maybe academic research on law. I'm particularly focusing in my own work, and other people at our center do, on how AI can and should be regulated. And we have all heard of potential problems that can come with the application of AI, discrimination, bias, issues around transparency, data protection, and so on and so forth. And so the question then is law the right venue, and can law help to maybe mitigate those problems and to regulate those problems? And one of the probably most interesting proposals in the recent times is the proposed EU AI, EU regulatory framework, or the so-called AI Act, in order to address these issues. And again, I don't want to go too much into theory because it might be quite boring for some people. But we obviously are in a very complex area. We have a not very defined technology. We are dealing with a moving target, really, because it is constantly developing. And at the same time, we have problems such as trans-border activities. So then that kind of really puts us into a regulatory environment that is not unique to AI. We find that also in other technologies or in other areas, but that definitely proposes its own challenges. And so what we all find in in order to capture this better is maybe this idea of having decentralized regulation that includes not just the question whether it's different states that regulate or maybe international institutions or supranational institutions, but also the inclusion of private actors, which is something that I'm particularly interested in. So one really interesting idea to capture that comes from Lawrence Lessig, who might be known to quite a few of you with his famous word code and other laws of cyberspace. And he coined this difference between what he called East Coast Code, which really refers to more classical and traditional lawmaking. So statutes that prescribe behavior come from Congress in this case, or from a national legislator, versus West Coast Code. So code that is written by code writers, but can also originate maybe from, he doesn't really frame it like this, but we can also think of technical standard setters or standards communities. And so that is a more of a decentralized model. And then what's really interesting, and this is also at the core of my research, is the interplay between these two types of regulation. How do they integrate? And so when looking at the EU's proposed framework, I think what we can see, and I will outline it a little bit in the next slides, is the EU pursuing of having a more controlling or steering role of otherwise, to a degree, decentralized activities. So the idea is to make sure that things go in a certain direction, certain activities are prohibited and are not happening because they are considered too harmful, but at the same time, we do not want to curb innovative business activities. So this is, I think, the main challenge. Now, maybe let's go a little bit into the proposed AI Act and what's envisaged there. So, a second. The proposal was, just some general information, was published by the Commission after an extensive drafting period in April this year. Its central goal is to ensure trustworthy AI, which is to be achieved through a risk-based approach. And the proposal applies to any AI system which is used in the single market. So the provider or the developer can be located elsewhere, but if it is introduced into the single market, then the proposal is supposed to apply. This is quite interesting. Also, the general framework that's applied here, people who have dealt with the general data protection might see some elements there. And if there's anyone listening in today who knows about the new legislative framework and particularly product safety regulation in the EU, will also find a lot of parallels. So whatever is introduced here isn't a completely new idea on how to regulate something, but it does take some ideas from other regulatory frameworks in other domains. So if you're familiar with the GDPR, you might be familiar with this concept of imposing fines that can be up to a certain percentage of the annual turnover for non-compliance, and something similar is also foreseen here to different degrees depending on the kind of transgression. What is important to maybe mention quickly is that currently this is just a proposal. There has been just a public consultation period which ended, and the proposed act still needs to pass Parliament and be approved by the Council of Ministers. And then there is a 2-year implementation period that will follow. So this is all still in motion, and we'll need to see where it ultimately ends up. So now what is central, and I think I will focus on that and then see if there's more time, or I will stop after this. I think what is very central to the regulatory approach is the so-called risk-based approach, which again is quite unique. Risk-based approaches can be done in a variety of ways. Some of you might be familiar with risk-based management, such as ISO risk-based management. The approach the EU chose, or the Commission better said, is that of a 4-tier system. It starts with a so-called unacceptable risk, which is defined in Article 5, and that is AI systems which manipulate human behavior to circumvent free will and cause harm, which exploit vulnerabilities of specific groups such as minorities, people with disabilities, and so on and so forth, which enables governments to implement a social scoring system, which we, for instance, know from China, or real-time remote biometric identification by law enforcement, except in certain circumstances. This is a very contagious topic. I think that's debated quite a lot at the moment because there are these exceptions. And those kind of applications are banned. What then really is most interesting, also from a research perspective, is so-called high-risk AI. And those are systems that are defined in Article 6, and there are 2 types. The first one, again, follows this line of product safety that the EU has in the so-called new legislative framework. And here the safety, it refers to safety components of a product or a product that itself is already covered by this product safety, so the EU harmonization legislation, and that already requires third-party conformity assessment. So these could be, for instance, toys or pressure machines and machinery directive. And so it's a list of existing directives that fall in this category. And additionally to that, the proposal lists a number of areas where high risk is also to be expected. And those could be critical infrastructure with risk to life and health, in contexts where AI could determine access to education or professional training, in employment and workers management context, with regards to essential public services, law enforcement, migration, asylum, border control, and administration of justice. Those applications are not prohibited per se, but there are strict obligations before they're put on the market. We then have limited risk. This is particularly in areas where there is probably a need to let individuals and consumers know that they're engaging with an AI, for instance, in the context of chatbots. And here we have predominantly transparency obligation. And then we have everything else, which is considered minimal risk. And there's free use and potentially voluntary standards. Now, when we think of the high-risk AI, what are the requirements? So before they put on the market, a high-risk AI system needs to undergo a number of technical and regulatory requirements. So they need to have an adequate risk management system in place. They need to provide adequate data governance based on training, validation, and testing, the data sets that meet the required quality standards, technical documentation and record keeping requirements, transparency and information provision, insurance of human oversight, and high level accuracy and robustness and cybersecurity. Now, this sounds quite general. It is more defined in the act itself, so there's a lot more details. But importantly, there is a lot more room for specification that can both come obviously from the providers themselves, who have to set up the regulatory tools to ensure compliance with those requirements, but that can also be provided by other private actors such as standard setters. And if we want to understand how the system works, we can maybe look or how this is implemented, we can maybe look at this not so easy graph. So basically what the providers of a AI application have to do is they have to put in place a quality management system. And this quality management system has to implement these Chapter 2 requirements that I just outlined. And then there's a way in which this is controlled. So this can be controlled either through an internal control venue, or more likely through a conformity assessment, which is defined in an annex to the proposed act. And such a conformity assessment would then be conducted by notified bodies who would provide certification. And ultimately, once a product is considered to be, once a quality management system is to be considered to be in conformity with the proposed AI Act and the requirements therein, the product or the AI application can get a CE marking, which we, as said, already also know from product safety applications. Am I overstretching my time terribly? Because I could stop here.
If you round off now, it will be perfect.
Okay, then I'll just leave it here.
Okay.
And maybe we can talk of some of the other things.
Absolutely. So, of course, I've heard of these EU regulations or suggestions for regulations before. And what's struck me now and struck me last time is that many of the obligations are kind of obvious, meaning that you should have security in place, etc.
Yes.
Is that common in the legal way? For me, it's like, yeah, of course, I'll do that. Yeah.
Well, as said, so I didn't go too much into details. The Act itself gives quite a bit of specification, so a bit more than just, okay, you have to have a security system or cybersecurity has to be ensured. So there's a little bit more specification. What is also to be expected is that this will be potentially linked to so-called harmonized standards, meaning that there will be a standardization of what that exactly means. And you might be familiar that a lot of standardization is already ongoing in the with IEEE or ISO and so on. So they're already quite busy setting standards for these different aspects that surround AI, whether it's more ethical concerns or whether it's more security or safety issues. With the EU, what is envisaged in this proposal is so-called harmonized standards. So that means the Commission can commission ETSI or CEN or CENELEC to set even more specific standards of what that means. So it can actually become quite detailed rules, depending on the issue, because it's probably not so easy to set very specific rules that fit all types of AI applications, even within this high risk category. But that's something that can be envisaged, yes.
Absolutely. And how do you, so Merete, does this regulation influence your company at all, or is this something that is kind of, don't care?
I haven't followed this this law at all, but I see it's when reading. I read this book called Weapons of Mass Destruction, and that's sort of my understanding of this high-risk AI, what it can do. And so I say this is a good answer to the challenges I see, but I don't think we will be a high-risk sort of, or the AI that we will create would sort of fall into the definition of high risk, even though I haven't really read it closely, but that would surprise me because it's an internal linking system that doesn't really have a consequence, a high risk consequence, as Rebecca pointed to, with entering into schools and whether you should get employed and so on. It doesn't have those consequences.
So my impression is that a lot is in the high risk. So what do you think, Vito? Do you have knowledge of whether Merete's company will happen in the high risk part?
So just off the top of my head, this is not an area that I follow, despite having a company that kind of moves within this context. I would imagine that this sort of companies will maybe fall under the limited AI risk, because it's just again as an immediate reaction. So if any, there's more a question about this fall within the regulation of the legal services. In particular case of Lexploria, the primary target is really business to business, commercial interactions. So there's no envisioning of consumer-oriented products. But so this is just really reflections off the top of my head. And I think there's, as in all legal definitions, you need to really go on the nitty-gritty and see and look at also all the surrounding documents, interpreted documents. So it's difficult to say just on standing 2 feet.
Of course, we will look into it, of course. But did you
I
say
have
that?
to say, Morten, that even if we are, I think we are pretty good, well equipped to tackle those regulations. I mean, we already have internal review system in place. Like our concept is lawyer in the loop. So it's the AI is never going to push out the information and decisions that we haven't qualified.
Exactly. So that is kind of what I meant by obvious, because you obviously have some security in place and you obviously want to explain why you come with this advice. At least that's clear to me. So, and then from a legal point of view, that's probably okay. But I would argue that many of the technology companies already do that. Maybe not all, but many. So that's good. But it fits into this kind of dilemma that we see many times. It's hard to regulate a technology that's for all practical purposes is emerging now. And what will be the implications in 10 years or 15 years or 20 years? Hard to say, right? So what was the implications of social media that came 20 years ago? What was the implication of smartphones, etc.? We know now, but back then we didn't. And I guess we're in the same place with AI. Or do you agree with me, Rebecca, or am I speaking out of?
Yeah, I think it is a very challenging endeavor to want to regulate AI, because it's hard to really foresee where we're going. And I think what the EU has been doing in a way is just to choose sectors and fields where it feels that there could be problems. Mm-hmm. So it's really maybe more of an act of defining areas that maybe already where already problems are emerging. So we can think of law enforcement, for instance. That's something we're all aware of. We have heard of the social scoring systems and so on and so forth. So there are some emerging areas where we already know there is a problem, maybe not in the EU, but potentially in other parts of the world. We have applications. I thought of the administration of justice. That is not obviously not Merete's case or what Merete is developing and working on. But there, I know in the US, for instance, there is this usage to foresee the probability of an offender to reoffend. And so that is based to a degree on machine learning and AI systems. And so those kind of things we might already, we already know that this could be problematic areas. And I think those are captured here. And then possible areas that could present problems in the future. But they are obviously, if we think 10 years down the line, we might have just gotten a fraction, or we might have gotten, we might have overstretched in some areas. So there's always this risk. So what I think happened here is really just try to define where potential problems are and trying to come up with a system that could regulate it. And it's to be seen whether it will be successful in doing that.
Yeah, so, and of course, and these are regulations that are expected to stretch across EU, which includes Norway in this case, I would expect. And I would say that this is challenging both when it comes to regulation, but also when it comes to delivering services, as for example, Merete does. So you talked about the Norwegian market. Merete, have you also talked about or considered going internationally with the product you have?
Yeah, absolutely. That's in our plans. We haven't, it's not going to happen this year, but definitely going outside. Actually, I had a question for you, Morten. So for the AI regulation, what does it replace? Because you said like it's already in how we develop AI today, that you have this internal policies and security lines. So do you think it actually will change anything? Like, but it's more of a code of conduct today, if I understand it.
Maybe I think it will change, because even though it's obvious, as I said, for many, it's not for all. And I would say that it kind of levels the playing field a bit because transparency, for example, some big tech companies, I'm not going to name names, but some of them don't deliver that, but a lot of the smaller ones do. And then when you deliver law enforcement AI or hiring AI and you have a transparency on top of it, this is something that it's easy for a big tech company to say, yes, we have, but now it's, I guess, probably a legal way of doing it to claim that one of those tech giants should also have that when they deliver it. So that's the big difference I see.
But it's,
yeah,
because that's a question for you also, Rebecca, because this is an EU regulation.
Mm-hmm.
Well, what will happen with those kind of companies that's based in the US, but to have technology in live in Europe? Would they need to comply with this new regulation as well?
Yeah, so it works well, similar and differently because the GDPR is different. So I said it is based really on this older idea of product safety. And so they are also, if you introduce a product into the EU market, you need to comply with these safety standards and you need to get this CE marking. And so the idea here is a similar one. So if you introduce an AI that is high risk into the EU market, whether it's developed somewhere else, whether your company is incorporated somewhere else, but once you go this step, you have to be in compliance with this proposed act. So that's the idea. And I mean, we also know that from the GDPR, once we use European data, then the GDPR is applicable whether Facebook is located even in the EU or not. So,
but how is that in practice, for example? Because if I take my health data, for example, and I send it to the US, I'm allowed to do that.
Which you're not allowed to do.
I'm not allowed to do that. Okay.
Actually, there is. Oh, yeah, I'm not a data protection expert, so you kind of met me on the wrong foot here. We have people who are, but there have been cases in recent years, in particular, of transferring data to the US, and it's especially because of the involvement of secret services in the US, which have been like mining data across the globe. There has been quite strict rules of not transferring data, especially to the US. And then there are obviously data protection laws in place in Europe, which are applicable. But technically, if you are mingling with Europeans' data, you have to fulfill the data protection requirements set out in the GDPR. But again, this comes from someone who is not a expert on GDPR.
I was under the impression, it might be a bit I'm wrong, but if I give consent to, for example, letting my app send a heartbeat to US, I could do that. But is that?
I do not think that's the case. Okay. I think there has to be, so Facebook also is not supposed to store our data on US servers. So
okay, I'll stop sending.
There have been cases in recent years, and again, you are kind of meeting me on the wrong foot because I'm not a data protection guru.
So how does Lexolve? How does your company work with that, Vito? So there's this cross-border challenge within Europe, but also outside of Europe. Are you focusing only on the European market, or only the Norwegian market, or is the world your oyster?
So let me start by saying we haven't really considered in any depth these sort of issues, but we do aim at the European market, at least to begin with. There is a number of the data sets that we are starting to process that will have a global market, and namely all those that regards public international law. But we are far still from having anything that it's to be released in the market, and we will come down to those sort of questions at a later stage. We are really still grappling with developing the product, but it is an interesting question. But again, I think more pressing will be, from our point of view, issues of product quality and potential issues of liability in terms of business relations than directly this. But of course, this is again also complex, and also they meet other So there is an important cultural difference between the United States and the European approach to this sort of questions. They created problems on many kind of fields of regulation, and it will be. And there's also another distinction to be made about what is done and what is done legally. And it's not always a good overlap between the two.
So tell us what is the difference between being done and being done legally for a non-legal person?
Well, so you can still do things and not being in compliance with regulation, and so the question that may or may not arise depending on whether this issue is raised. I think that's an important difference. For example, when you ponder as to whether certain data are transferred or not, is also about whether they're transferred legally.
I see.
Or so it's it wouldn't like it's just a normal standard that there's like different kind of levels at which you look at these sort of issues.
I understand. But if you think of Lexploria, so if I understood you correctly, you kind of collect not individual data, but at least scientific data, and I would imagine that most of that is, or at least some of it should be public, but not all. From private.
No, so that's an issue of access to data. So some data sets are publicly available for commercial utilization. Some others, no, they're not. They're protected by intellectual property rights, and then one will need to enter into commercial agreements in order to utilize for a commercial purpose such data.
And how do you go about?
In fact, some of them are protected even for academic usage. So if you don't have an academic account paid for, you can't access. So this is an issue which is a barrier in terms of the speed and freedom to develop products for Lexploria. But that is about just that access and utilization. But the data are otherwise available in a number of ways, and they don't pose necessarily problems of privacy or so the issue is more when collecting data of users that would access your system than you would have GDPR's issues. And I wanted to say something about transparency, and then maybe this is both a comment and a question for Rebecca or also for Merete, because so transparency, of course, is a very important element in how one deals with these sort of questions. But I wonder, and this is the question, whether transparency may also have a potential problematic implication, because it's still so it may help you understand how you reach certain outcomes, but it doesn't really address the consequences of certain outcomes unless there is mechanisms in place that may be actionable in that respect. So transparency is only one part of the question, and it may also offer a false sense of security, if I can put it that way, in a provocative way. So I just wanted to hear if maybe Rebecca or Merete has, or you have any.
Let's start with Merete. So how is transparency part of your service, and is that enough to kind of develop trust in your service?
I'm not sure what that will at that point yet. Of course, we are creating the architecture, but how I understand the question of transparency is how you show to the users what you are doing and how you're using that data. I think that would be fairly obvious for the user, that we use the data that they give us, that we use public data, and that we also lay on information that we get from similar companies. And of course, we're gonna provide that feedback back. Transparency is actually one of the core values in the company, like regardless of the AI. So I think it's a very important thing to do. But I haven't really thought about it in the AI perspective. But I think that's about, because we need to build trust in the system as well. We have a human lawyer in the loop, but the more we have automate stuff, the more trust you need to show. And I think part of that the question to show trust to your system is exactly transparency.
Oh, exactly. So I guess it's different levels. It's kind of transparency of what you're doing, and it's interpretability of the algorithm, and it's in the end explainability, which kind of like as a lawyer or a non-lawyer, you would kind of need some sort of explanation of what it is. And these are very challenging, and there's a lot of research money to get there. How does that feel in the regulation part? Is there any requirement or expected requirements on we know about transparency because you mentioned it, but on interpretability and explainability?
Explainability, I would not need to look. Yeah, so as said, the requirements do foresee transparency, and I also wanted to kind of move to that maybe distinction between transparency and explainability, because I think those are two different things. My understanding right now is that when it comes to high risk and the high risk requirements, it doesn't necessarily, or it is not the central focus to just the engagement with the user, or less maybe than it is, for instance, with regards to the GDPR. Where we do see this transparency requirement is in the low risk, or when we, which I made the example of chatbots, for instance. So there we do see more, okay, here a user needs to be aware of what's going on, that he or she is engaging with an AI. But when it comes to high risk AI, my understanding is a little bit that first and foremost, how this works, because it is modeled a little bit on this product safety line, is that we want to ensure that before any AI application is put on the internal market or into the internal market, we have ensured a certain standard and compliance with certain requirements. So those include transparency to a degree. So we don't want to have a black box kind of situation where when no one knows what's going on. And there's obviously importance when you think of some of these applications as with regards to workers and with regards maybe in border control context. But, and again, I would need to go through the details a bit more now. My understanding is not that the primary perspective here is maybe a rights perspective of individuals or consumers, as we see that a bit more in the GDPR, where we have this idea of a risk to a right. So it's a bit differently conceptualized. That's
absolutely.
all I want to say.
We just need to round up because time is running so quickly. We always end the NORA Startup webinar with a single question for all, and I hope you can answer quickly. And this is, in light of what we've learned today, a lot about what we have talked about, how do you see the ideal support or help or collaboration with a company or a group such as NORA and NORA Startup? So Rebecca, first you. So what 5 years from now, what would NORA Startup be for you if you say, this was a successful way to help me?
Well, from an academic perspective, and I might have a very different one from the other two panelists, but I am interested in really what practitioners, what businesses are mostly interested in and what they are mostly struggling with, and to understand that and to have that input into my research as well. I think that's something where I think NORA can be very beneficial.
Good. And then we go to the academic, semi-academic Vito. What would be the ideal NORA startup?
Yes. So which hat does she use here? I'm not sure, but so no, I think I mean, if just a bigger, better version of what's already going on. I think it's, from my point of view, it's really, really good to have been kind of involved into the NORA consortium. It's really, really useful to get together with other companies, with academia, with different perspectives at the technology level, the legal development level, and even if I'm academic, this is a field of law that I don't really practice. So for me, it's useful also in that respect. So I think that this is really just to keep going in the same direction and just enhance these sort of events, and hopefully it will be also easier to do this in person soon enough.
Merete, last word from you. NORA Startup, what would the support you need be?
I think having this community is great, and also it lays the opportunity to identify where the same sort of, at least startups and companies, struggle with the same AI challenges, and that we can put their heads together, because I always believe the collective intelligence is better than the individual ones. So I think NORA can be sort of a key into figuring out who's struggling with what and bring them together and be part, of course, of the university, as we want to be close to as well.
Perfect. And then with that, those nice words, we round off, because this has been a very exciting talk between Merete Nygaard, Vito De Luca, and Rebecca Schmidt. And this is clearly a topic that we will visit again in later stage. But please tune in to the next NORA event, which is next Friday at 2 o'clock, and the next NORA Startup event, which is in 2 weeks at 2 o'clock. Thank you and have a nice weekend.
Have a great weekend.